Hi guys, it's Kathy. I hope you're doing well. This Monday morning, Monday. Not raining outside, so it's not a rainy Monday, but it's almost a rainy Monday. We just got done with the stream. It was a good stream. It wasn't the best stream I've ever done, but it was okay. Now we're gonna do another one, and we're going back to that judge. I don't know her name. It's Texas. It's the one where it's civil cases, and she gets a little criminally today. She's not happy with just civil cases. She pulls out Miranda rights right in the middle of trial, right in the middle of the hearing, and then sentences them. Oh. Here we go. She's a little loud, though, for a Monday morning.
Right, you are here on the LCG, right? LGC. Okay.
Yes, Your Honor.
You remain standing if it's more comfortable for you.
Thank you.
All right, so this
first one, there's two cases we're going to watch. This first one doesn't have a verdict, unfortunately, because I'm dying to know what she's going to rule. Two story or one story. It all has to do with did I put it in? With the flood that happened with Harvey, the hurricane that hit Texas. Harvey, was it Harvey that was really bad? So it all has to. It's just they made new laws since Harvey, and now. All right, here's what's really going on. There's a lawyer who lives in a neighborhood, and his neighbor's house is being upgraded and is going to be taller than his house, and he is pissed off.
cause number 2024-85154. This is LGC Builders LLC versus Michael Knapp. If I can go ahead and get the appearances, let's begin with LGC.
Ricardo Ramirez Fernandez for LGC, Your Honor.
Christine Reynolds for Michael Knapp, individually and derivatively.
Okay, Christine.
Rennie, R-E-N-N-E.
Okay.
And Giancarlo Ortega.
All right. We're here on a show pause. I saw it in the file that there was a...
It's my fault. There wasn't a verdict in the attorney case, so I cut it out because I didn't want to piss you guys off. So we're not going to see that because there's no verdict anyway. This lawyer, he had a house. The other guy was upgrading, so he took him to court. And he says, you're not allowed to do that. You're only allowed to have 2 stories. But Texas had come out with new laws since Harvey. And the first layer has to be flood proof. So they put like this garage, which is not in a habitable area, so that was allowed. And this other like decoration for water to go through, but it's not really a part of the house. It's not, you can't live in it. When you go into the garage, you have to go up a flight of stairs, a full flight of stairs, to get into the house. And then there's the main floor, and then the bedrooms. And that's 3 stories to the lawyer. The lawyer's like, that's 3 stories. His house is going to be significantly bigger than mine. And he keeps saying it. But she doesn't answer, so I think I cut it out because of that. It's okay. We have enough with this guy. He's here for a show cause in a civil case. So we shouldn't need handcuffs.
Compliance notice submitted by the defendant. What's going on?
Your Honor, we produced everything we had. The only thing that I do believe that it is missing is stating that everything we have produced. But other than that, Your Honor, in the notice of compliance, we detailed everything we produced. The fact that they're now asking for more stuff, it's just beyond my comprehension. For instance, Your Honor, they, in their first section of the response, they state that they've been after books and records. Your Honor, we produce bank statement, tax returns, P&Ls as ordered by this court. They also stated that there was a missing email. However, they claimed that the single piece of or single line screenshot that they put in there was the end of the email. When in fact it was 2 pages that were produced. It was the complete thread in there. Additionally, in page 9 of the response, they are stating that we are missing to show some documentation from loans from NAP to LGC. However, they haven't produced a single shred of evidence showing that NAP indeed put that money into LGC, which is another issue at dispute. Your Honor, simply put, I do believe that the fact that we are here is because they did not receive what they thought it was going to be there, not because we didn't produce it, but because it is not in the records. Your Honor, we have produced everything we've had to the moment. I do believe that EZQ Group has some more documents. We haven't gotten those yet. So, Your Honor, so far, I don't think there is a need for a contempt hearing or a show cause hearing because so far we've complied with what the court ordered and they actually received those documents.
Okay, so, Ms. Rennie, what is it that was requested that has not been received?
Yes, Your Honor. I actually took the order to show cause and I've highlighted. Would you like a copy?
I'm just looking at it now. I mean, when was it filed?
Well, actually, it's in my response, but I can tell you, on page 4 of the show cause order, you ordered.
I'm pulling up the order. Give me a second. I need a copy. Let me have it, please. Seems the printer is a little slow today.
So am I.
Yo, so am I, Judge. Don't worry. Guys, you can only see this judge here on this channel. If you're not subscribed, subscribe now.
That's from our friends at Third Boss.
Monica's on a 9-month streak on Twitch. Thank you, Monica. Thank you.
Thank you. Awesome. Now I just need the rest.
I would love to, Monica. Thank you very much. Please, please, pretty please. Overload.
Oh, this is insane. Right, so the first item I see in the court's order are bank account records. Have they been produced?
The bank statements have been produced, but in the order, the opening documents, account applications, signature cards, signatory approval, and removal cards were never produced. They're the ones who have access to the bank account. I just crushed it. So they did not comply with this court's order to produce those documents. And the significance is because Michael Knapp is and was a 50% member. And when they had to open up the bank account, he had to go in with Ms. Salgado and sign on to the bank account. So he was a signatory on that account until somehow he mysteriously got removed. So these are really relevant documents. This court ordered that. They still didn't produce them. They only produced the statements. And they had already produced the statements before and came here in February for the show cause order, and we raised this issue, and that's why this was language was specifically included, was they had to go get those, and they didn't. I got the same bank records that I'd already gotten.
If I may, Your Honor, there is an email from, exactly who it was, that up to this date, LGC has not produced a single subpoena to any bank. We received a notice of intent to subpoena the bank records. We moved to quash. We submitted a letter stating, hey, you know what, we'll bring this to the court before you produce anything. And today, as a matter of fact, at 11:13 a.m., I got an email from the legal administrative assistant for the law firm handling businesses for one of the banks, saying that they have never received a subpoena. So the fact that they're saying that they requested or they submitted the subpoenas and never got back to them, or that we quashed them, that's just complete.
Okay, these are your bank records.
Yes, Your Honor, that's what we have.
Okay.
Bank
Have
statements.
you gone to the bank and asked them for the account application, the signature cards, or the signatory approval or removal cards? You are the holder of the account. You have control over those documents.
Yes, Your Honor. It is,
Gone to the bank and asked them for those records.
I'll have to ask my client about that, Your Honor.
Okay,
Me personally, I have not, because I am not the signature.
you understand that this was a show cause order, correct?
Yes, Your Honor.
Okay. The second item are the profit and loss statements. Okay, and those have been produced already, correct?
Yes, they were not part of the court order because they had been produced.
Okay, the third category are the construction contracts and related records for construction projects.
To revisit one issue also on the bank account issue, that LGC had another bank account. And
You have to speak up, I'm sorry.
oh, I'm so sorry. I'm so sorry. LGC had another bank account, and we were able to show that in our response because there was an invoice showing paid for $103,000. And when I went to the bank records, there was no entry. And that's my exhibit D to my response. And they were supposed to, pursuant to the court's order, provide an affidavit affirming that identified the Capital One as the only bank account. And they have not provided that affidavit. So I think that's sort of an admission that there is another bank
There is another bank account, guys.
account. I don't know what the number is, but they failed to provide the affidavit as so ordered by this court.
Okay, where's the statement regarding the affidavit?
I'm sorry, what was that?
Where's the statement concerning the affidavit?
Because
On what page of the order?
I'm so sorry, on page 4 of the order.
Is that a trick question? Because one of the cameras is facing behind them and one of the cameras is facing towards them. So I don't know if I can answer that. Hi, Shannon. So
Right.
I'm going to say on the right.
What is the next category that you have a complaint about?
Okay. It's going to be not the side with the lady and man lawyer standing up. It's going to be the other side. Okay. Also, the audio separates, and I tried 4 times to fix it. It didn't fix, so just don't look at the mouths moving, which the mouths are really tiny, so you can't see them anyway.
Yeah.
What is the next category that you have a complaint about?
Not having that figure, we want to know where to start that one. Okay, great. The next one, the construction contracts, they did produce some. One of the biggest, the Provere, was not in there. But interestingly, the document that started the construction contract, and it's on page 4 of my response, was a document, and it's entitled Exhibit D. And the title is, the contracts with past project experience. It lists 4 projects, and it only produced the records for one of the project, or only produced some of the contracts for some of that. But it begs the question, if your first page is Exhibit D, where's the actual contract for those? And where are exhibits A and C, and are there any other exhibits? So although we did get a little bit more in terms of contracts for projects, it was clearly not the complete set of contract documents. In addition, they had previously produced a sales by customer, which showed almost 600 entries. And yet, we had pages of contracts. So, the court had ordered on page.
All right, so I'm gonna have you all we're gonna have a hearing. And you're gonna have to call witnesses. It's a show cause, and we'll go from there. Okay, so, but I'm gonna take care of the rest of the docket at this time. So, I'm gonna call 2025-11237. This is Daniel Maldonado versus Michael Maldonado.
Please out, please, for the plaintiffs.
Okay, tell me your last name.
O-R-E-I.
Anybody else here on that case? Is there anybody else here on the Maldonado case? All right, Ms. Ortiz, this is a status conference concerning.
For motion to compel.
Were you the movement on this original motion?
Yes, yes.
Kelly, thank you so much. Thank you.
Are you here on behalf of?
Plaintiffs,
And
the movements.
Mr. McQueen is the counsel of record?
Yes. Yes, I'm the associate.
Oh, no. They're coming back. They're coming back as soon as soon as she gets through some stuff, which I thought I cut out, and apparently I left it in.
Okay, where are you all? I understand that he's finally complying and has given you access?
Partially, Your Honor. So, Mr. Maldonado has signed the listing agreement. However, the broker made a punch list to make the condo ready for sale, right? The condominium is in a state of neglectment. It has to be thoroughly clean, many items removed and all that. And while Mr. Maldonado has been responsive in a way, he has done anything since February 21st that he signed the listing agreement. He doesn't hasn't provided a date to when is it going to be ready, the condo, and he changed the locks so the other siblings cannot get in and try to help him.
Okay. Was Mr. Maldonado served with the court's order?
Yes.
So, Mr. Maldonado, I think it was a parent's house. Mr. Maldonado lives in it. Parents passed away, so now the siblings get to, do whatever with the house. But he's a hoarder, I think, and the house is uninhabitable, and he refuses to let anybody in.
Yes, but because he's a pro se defendant, we are not sure that he's keeping up with the court's emails and all that.
What is it you suggest?
So we suggest to have a 10 more days to communicate Mr. Maldonado that he has to comply in full with the order. And if he doesn't, we will file a motion to request the court to hold him in contempt of the court. Because with our first order, he partially complied and agreed to sign the listing agreement. But we believe that if he feels that the court is on top of the case and he will be compelled, he will get the condo cleaning, make it ready for sale.
Okay, so I think I have a better idea. So I think we should enter an order that basically says he needs to clean up the place within 10 days, or on the 11th day, the court is authorizing someone to come in and clean it. But if they have to change the locks.
Okay, that's perfect. That's perfect, Your Honor. Yes, that's absolutely great. So one of the siblings is willing to do this. Well, they live out of town, but he is willing to do this. But we were worried that because his personal belongings, personal property.
I gotta get it cleaned up. Okay, so give him 2 weeks. How about that? We'll give him 2 weeks. If he doesn't get it done within 2 weeks, on the 15th day, we'll be sending in a cleaning company.
Yes, Your Honor. Thank you. We will do
We need to
that.
draft the order and send it in.
Yes, I will do that. Well, thank you so
10
much.
days is not enough time to clean that. Welcome back to Let Go.
You guys here on the 2-story versus 3-story?
We are, Your Honor. Early call.
Yes. Yes.
And I'm wrong again. I did leave it in. I'm sorry. I have no idea what we're watching today. Apparently.
Me
Glad we could accommodate.
too. Although it seems I'm gonna have a little protracted hearing afterward. My report is going to call clause number 2020 and get the appearances from the parties. Let's begin with plaintiff's counsel.
David Nguyen, Your Honor. On behalf of myself, counsel, and pro se.
Okay, so you are,
He is pro se even though he's a lawyer, if that makes sense. He is pro se. He is a lawyer. He is an asshole. Sorry, did I say that? I meant it. This is the one, guys. So he owns the house that's going to be shorter than his next door neighbors, which is going to be longer.
counsel pro se.
Yes.
Thank you.
Dwayne Day here on behalf of all the defendants, Judge.
All right. So is it 2 stories or is it 3 stories? Who filed the motion?
We filed a motion, Your Honor.
Okay, proceed.
So as you know, it sounds like we're here on a deed restriction case. It's interpreted as a contract. And in this particular instance, the language we are focused on is a provision in the subject deed restrictions that provides that residents are to be no more than 2 stories in height. This is a relatively small subdivision of 8 lots. There are 7 homes on it. And now this lot that the defendants are seeking to build a spec home on, the final lot. And their building plans clearly have a design for 3 stories. The first they call the ground floor under their building plans has a garage, full 10-story ceilings, a workspace, sheetrock walls, windows, covered patio, a full floor with even an elevator stop on it. Then above that floor, they have what's described as the main residence. And then according to their building plans, they intend to build a 3rd upper level. And Your Honor, we've cited to the court several cases that have actually reviewed similar language in deed restrictions. that limit a residential build to a certain number of stories. And courts have repeatedly held that that language is indeed unambiguous. We've cited the court also to Webster's Dictionary for that purpose. And these courts have uniformly held that language to be enforceable and, as I said, unambiguous. So we think it's a straightforward case for the court to decide on that issue alone. Now, they have raised their key argument is that there is a Houston ordinance that requires building at a certain elevation, a minimum elevation. And we've also cited to the court several cases, the BCH case and the, I think it's the not June.
A certain elevation is not 10 feet, is it?
It's roughly where they've built it to. The first ground floor, whatever that is the elevation they argue they had to build it to meet this ordinance of the city.
Okay.
And Your Honor, that of course, that ordinance was passed in 2018 in response to the Harvey flooding. These deed restrictions were created and entered in 1970. And both the BCH case and the Jennings case that we've cited, Your Honor, and both after the deed restrictions were agreed to and entered into, and the courts rejected that. They said, first of all, this is typical for how they should be enforced, much less a statute or ordinance that was passed, decades after our cases that say this language is unambiguous and point to this ordinance of the city has been rejected by other courts, and there's no good reason for this court to take a different approach. The language is unambiguous, it's clear, and should be enforced as it's written in the restrictions. So, and then further, Your Honor, there's a way here for them to both abide by the ordinance and the deed restrictions. So the ordinance just provides for a minimum elevation for otherwise that anything built below the elevation has to be flood proof, if you will. And so garages are permitted, for example, but it's still a story. It's still building plans. So they could keep what they've already built and build their second story, finish it out, and you can have a residence there. What you can't do is get another bonus floor above that and say, we're going to close our eyes and pretend that this first story doesn't exist because of an ordinance that was passed in 2018 that says it just has to be flood proof. It's still a story, Your Honor, and they're permitted, by the way, at their current height, they're equal to the elevation of my home. They want to go a complete third in the neighborhood, and these deed restrictions were explicitly passed for the purpose on page 1 of having a uniform plan for the improvement, development, and sale of all the lots and the building sites. Their building would be much taller than other houses, including my own, which is right next door.
Right.
So,
Anything else?
the only other thing, Your Honor, is that I've got some objections to their summary judgment evidence. I'm happy to walk through those, or the court can take that under advisement. I would just ask the
Take
court
that under advisement.
rule on it.
I will rule on that.
Thank you, Your Honor.
Okay. Anything else? No. All right. Mr. Day.
Yes, good afternoon, Judge.
Good afternoon.
Let's start with the deed restrictions.
I got them.
Mr. Wynn, the problem is the city of Houston, because of the catastrophic events of Harvey, in the ordinance has actually defined what the first level in the homes. It's not that 8 foot or 10 foot on the bottom. That is not defined as the first level. It starts at the ceiling of that and then goes up as the first level. In the ordinance, that's defined.
Right, so I keep seeing crawl space. I think it was in your response that you're referring to this as a crawl space. Yeah.
Here's what the elevation of the house looks like. The already is the literally a crawl space that accommodates a garage. He's accurate about that.
Okay, do you have, I mean, from what I read, okay, the crawl space would have to have the ability for water to flood in and out.
And it does. That's
So the
fine.
water can flow through the garage?
Yes, we wouldn't be approved if it couldn't. There's specific vents on the outside of the walls that allow water to go through. You can't build without it. We would be causing his lot to flood more if we didn't. We have the certification of approval on that flood plan. That is important because in the VCH case that he represents answers the question here. They come up with the definition of what a story is. And they claim that it has to be between a floor and a ceiling, but it's got to be what? Habitable. And let me tell you the story about that case. That case was a restriction to a single level, one step. Somebody tried to get cute and modify their attic to live in. They have some attic space to actually live in, not store Christmas decorations and stuff like that, but actually live up there. And the homeowner tried to complain and probably said, wait a minute, you're making that habitable. So even though it's an attic, now it's habitable, so that's 2 stories, and that's the kind of story. So carefully worded that. Mr. Wynn wants to use the definition, anything between a floor and a ceiling. Well, that's not what his own case says, is the definition. It's gotta be habitable. Back to your point about the crawl space, allowing water to flow through. That's not habitable, because when the rains come, guess what's gonna happen? The water's gonna flow through there just like it's supposed to, through the vents that are designed and approved by the city of Houston to allow the water to flow through.
This is the garage?
No, that's just purely aesthetic. The garage is around on the side. It's just an aesthetic front. That's not a look.
Is this the garage then?
Yes.
Yes, back behind, the driveway comes
It
right
kind of
there, and the
slopes
garage
down.
is back behind there.
So behind this window,
Yes, and down below.
okay?
So by his own case law and by the city's definition in the statute,
LV, this judge could take this attorney easy. I put all my money on her.
in the ordinance of what.
What is this?
That's just an aesthetic front. That's not a room. That's not habitable. It's nothing else except cosmetic to make the front of the house look better. And the board was very careful to recognize that bottom floor has to be, has a lot of water to flow through. Here's the most important part of how they define. After Harvey, builders were like, man, what are we gonna do? Because we can't build in the 100-year floodplain. So the city took it upon itself to come up with an ordinance that says, here's how you do it. You figure out what the highest 500-year floodplain is. You, the builders, have to build 2 feet above that. Why they chose 2 feet, I'm not sure. But that means our bottom floor is 8 feet high. And on the garage side, it's a little taller because the land is a little bit different and it allows for a 2-car garage. And that's it. There's an elevator to go down.
When you come in,
So that's the new ordinance. The new ordinance is you have to take the highest flood level for the last 500 years, and you can't start building the first floor until 2 feet above that. So they built a garage because that's not livable. That's okay if it gets flooded. Okay, they built the garage on the bottom, and then they built this just this structure that looks pretty, like a wall. You can't live inside of that wall, even though there's windows and things. To get to the living area, you have to go into the garage and up a flight of stairs. Okay, and that's when you get to the first floor.
Into the garage.
Yes, ma'am.
Do you have to go upstairs to
Yes.
go to the house?
You do.
Okay, how many steps are there generally?
I think
Like-
it's two little levels. One goes up and comes back. It's
a
yeah,
full-
pictures of it, actually.
Yeah, there's pictures attached to our motion. It's a full flight of stairs.
Okay.
It's 10 foot.
Just do you have them?
I'm sorry, I don't have my exhibits. Those.
No, I want one of those granny chairs that go up the stairs automatically. I want one of those. So the audio is separated. I could not fix it. It was unfixable.
As exhibits, so.
I have some of the exhibits, but not those.
Do you know what number they were on your
I
motion?
want to say to be 5. I can certainly get that.
Okay.
Look, right there, that's the stairs in the garage that go.
Okay, thank you.
Which is allowed by the ordinance definition of just reference fee, which is if you're allowed to have a garage and access to the main residence, even an elevator coming down is allowed, as long as you still abide by the flood regulations and allow water to flow through. I don't want to get too deep into the issue with the committee and the deed restrictions, but there's no committee to go to in this neighborhood any longer. So a builder like my client who paid $800,000+ for this lot, there's nobody to go to get architectural approval. Nobody. Because the neighborhood has decided to let the committee go and not have one. So what do? We go to the city, we get approval. We follow the flood regulations, we get approval. And only after we start building do we get one resident coming forward and saying, hey, your house is going to be too tall.
Okay, thank you. All right, Mr. Wynn, you get a brief reply.
Excuse me, Judge?
I said, Mr. Wynn gets a brief reply.
Thank you. The lowest level definition is. It does not define story. There's no mention of language doesn't match. It can't override the deed restrictions. Secondly, I would say the plain language of a crawl space, 10-foot story tall patio ceiling with fans and canned lights and electricity and windows, for crying out loud. It's not a crawl space. And I would also remind the court, these deed restrictions specifically state they refer to a first floor, second floor, no mention of a third, and they say garages are to be excluded from when there's a minimum square footage of living space, and it says garage doesn't count toward the square footage of a living space. So the drafters intended for a garage to be a living space, or else that exclusion would be superfluous. So there are other interpreting guidelines from the actual language of these deed restrictions that might not have existed in the BCH case when they referred to it being a habitable area. But I'd also remind the court, it is a habitable area. There is a workstation in there. There are finished floors. There's windows. It's a garage. Their own building plans say there is 3 floors of living area that we've highlighted and I think done a snippet from in our motion as well. And I'd be happy to show your honor if you want to see the building plans, but it shows there's 3 floors of living area according to their own document. I say it's also just an absurd argument to say, hey, as long as it's just a garage or water can flow through it, then ignore it for purposes of determining the height of this house and whether it abides by the deed restrictions. They could build a 20-story building, parking garage, and then a 2-story penthouse on top, and they would say that qualifies. We could do
That
that.
would be silly.
Or we could build a 50-story, what if he's got a garage of park, and then he wants to build 2 stories on top of that? You're saying that would suffice? The absurd argument is not the intent of the draft bill. It says 2 stories. Finally, on the committee, BCH, the defendant there raised the exact same issue. The court in that case said, just because it was impossible to go through a committee, because there's no committee members, they're all dead, and there hasn't been a new one, but that doesn't excuse anyone from just violating it. Because here, the deed restriction not include a method, whether by convict or otherwise, for obtaining permission to build a house. It was an outright ban on buildings more than 1 story in height. The same is true here. The committee issue is beside the point. Thank you, Your
All right, the
Honor.
court's going to take it under advisement. I should let you all know later than the end of this week. Thank you. Have a great week, actually.
Yeah.
Great week. Thank you. All right, y'all can come back up on LGC Builders.
I once caught a fish this big.
On the record in cause number 2024-85154.
Your Honor, walking up.
I said you may call your first witness.
Is Ezekiel Ortuno in the courtroom?
Okay, Mr. Rodriguez, are you here? Come on up here to my right, please. You all can be seated if you wish.
This is him. You can't see him right now, but
Watch your step
in
coming
a few
up.
you will.
All right, if I can get you to raise your right hand.
This is the defendant who is here for a show cause hearing for not providing documents about this other bank account and other things. Monica, thanks for the cheers. Thank you.
Solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth. Have a seat. All right, Ms. Remy, your witness. Oh, tell me your full name for the record.
Carlos Rodriguez and Carlos Delao. I just freeze my name.
Okay,
Delao.
thank you. All right, Ms. Remy, your witness.
Thank you. Mr. Rodriguez, you were served with an order to show cause, correct?
Yes.
And were you served by a process server at your house? Was that on or about February 14th?
Saturday, yes. It's a new car, so I don't know. License, please.
Is your wife in the courtroom today?
No.
On several occasions that the subject, meaning your wife, is not home, and that you advised the process server that you would both be at this hearing? So if a process server has provided an affidavit to the court saying that you told him that both would be at the hearing, would that be incorrect?
That's correct. What I'm talking. Can I say what I'm talking?
How many times do you think that the process server came to your house to try and serve Vilma Salgado?
The first time when he got me served, and then he came on another day when he was outside the shop.
May I approach and show the witness a document that I'd like
Sure.
introduced? Thank you.
All right, do you intend to introduce it?
Pardon?
Are you introducing it? What is it?
Yes, it is the process server's affidavit. It was attached to our response, and I think the process server actually filed it with the court.
Okay. Do you have any objection?
Introduce it.
Mr. Ramirez, any objection?
Is it the one that you uploaded this morning? I haven't reviewed, Your Honor. I was on the road on my way here, but if it's the same one that you uploaded this morning. I would like some time to review this, Your Honor. I haven't had the chance to do it.
And did you get served with it?
This one, I got served this morning, Your Honor.
Served on Friday, but it got rejected by the court, and it was refiled in an envelope. but he would have still gotten service on Friday.
No, I left my house this morning at 7 a.m. in order to be here.
Yeah, so review the affidavit.
I skipped dinner yesterday, so now I'm regretting that decision. Now I'm starving. I need food. He's about to say one thing, one sentence that buries him, and is makes the judge pass a sentence at the end.
Ms. Rennie, while he's reviewing that affidavit, please tell me what the relevance of service is on whether or not they complied with the court's order.
Your Honor, I believe that the court can only sanction somebody that's been personally served with the order to show cause, and we were only able to get service on Mr. Rodriguez and not Ms. Salgado. And so I wanted to let the court know that, as well as the fact that he's stated on several occasions that the process server didn't need to come back. Now, the process server knew he had to, but he's just denied it on the record, so I think it goes to impeachment.
You know, he's here, he was served, he was not served. There's nothing I can do against her. She was not served.
I understand, Your Honor, but his credibility, he's just denied on the stand that he didn't tell a sworn process server something, and the process server reported what he was told. It's a party admission.
Not a party admission, it's hearsay, if you must know. The affidavit of a process server who is not here to testify is hearsay. That's the objection, counsel, you needed to make.
Yes, Your Honor.
Hold on.
Okay, I will do so. When you received the papers, did you read the order to show cause?
You didn't read it?
No. No, because that's why we got an attorney. English is my second language. I'm not too familiar with languages, so I don't know exactly.
English is my second language, so I got a paper from the court, but I didn't read any of them. I just didn't read them.
What it is.
Did you ever read the order to show cause?
I don't know what is the order choice.
May I introduce the next exhibit? The
Sure.
first exhibit, I guess, thank you. May I approach the witness?
Sure.
The judge is so
Got a
mad.
copy to counsel.
She can't even say sure. Sure.
You recognize the documents?
Is that the one that they gave me, the gentleman that went in my house? But I didn't read it.
Did or did not?
No. No, I don't understand that.
Did you send this order to show cause to your CPA?
Again?
Did you send the document to your CPA or your bookkeeper? Did LGC employ the services of EZQ Accounting? And in fact, LGC paid EZQ about $37,000 to maintain its books, didn't it?
Maybe even more.
Did you ever pass?
Forget all of my other business ideas, guys. We got one. We got a live one now. CPA. We all become CPA and get $37,000 from small businesses. That sounds terrible. That sounds like we're crooks.
Pass along this order to show cause to Ezekiel or Tuno of EZQ?
I don't understand why you need to give it to him.
I'm sorry, can you repeat?
I don't understand why you need to give it to him.
Did you ever come to understand what you had been ordered to produce?
That's why we got an application.
Objection, Your Honor, badgering, I'm sorry?
If you want to talk to me, you're gonna stand up. When, especially if you're asserting an objection. Okay, when were you retained in this case?
Back in October, November last year, Your Honor, if I'm not
Okay,
mistaken.
great, thanks. When was the order served?
This order to show cause was served.
Bobby, I promise you, if you worked with me, it didn't matter what job we're doing, it would not be boring. None of it would be boring. I promise you.
Effectively on February 13th to Mr.
Of
Rodriguez.
2026.
2026, yes.
Okay, did you send a copy of this to your lawyer?
Yes.
Okay, go ahead.
Thank you, JK. I didn't realize CPA is an accountant. That's what we call our accountants, CPAs. But I mean, we have accountants, we have CPAs. So there are it is different, but I didn't realize everybody in the world didn't call them CPAs. If you just think of an accountant.
As you sit here today, do you even know what you were ordered to produce?
I don't know what is your question.
Did you yourself ever go to the bank and request copies of the entire bank records?
We send the statements that I believe on November 12th, when I came here without an attorney in the consulate, I was requested to send the statements for the one.
I would like to object as non-responsive.
So overruled, move on.
Do you know if your wife ever went to the bank to get those banks' complete records?
Speculation, Your Honor. Objection.
She said, do you know? It's overruled. Do you know?
No, the bank,
Yeah, so you only have to stand up when you address me. You can sit down otherwise.
the last bank,
That is the second time she has told you, sir.
the bank of the one channel that personal banker that you go to the bank and request, you gotta do it online, and that bank account is being closed for almost a year, so.
So it's your testimony, you can't go to Capital One and get the entire records?
Not to have the one, you gotta send an email, and then they respond you and they send the information.
Did you send any emails to the bank?
Yes.
Did you?
That's why we got the statements, and you got all the statements.
Did you produce those emails requesting the specific records that were in the order to show cause, including the application, the signatory cards, and any removal of any signatories?
This is the first time that we hear about the signature or the cause or whatever you're asking. This is the first time that we hear about it. We even
Hearing, were you not, in February of 2026?
it was fairly good. Yeah, I was here.
Purveyor contact?
No, they stopped paying me, and that's what we stopped doing the work. We got,
Did you produce the Purveyor contract? So it's in the documents? Was it an AIA?
AIA.
Okay. And so if the only AIA document in the production is an Exhibit D, do you know what happened to the remainder of the Purveyor contract?
Yes. We were checking with the attorney early, and he got a whole thing.
And so if only Exhibit D was produced,
No, it was produce everything.
It was what?
It's produce the whole contract.
AIA document contracts, construction contracts are quite lengthy, aren't they? Hundreds of pages?
Yes. And it's been produced.
And so if only 200 pages of contracts for all 4 years for LGC, as you sit here today, you're testifying that all the contracts were produced?
Contracts that we had, there were contracts like 3,000, 4,000, and there were like in boxes, we didn't put it on record and compute it or scan it or keep it on record. So many of those documents, they got lost. We didn't have like 4 or 5 different secretaries through those years, and we lost a lot of information. A lot of information was feedback, you client Michael that. He keep that on the record, so he should have a lot of those records.
It's your testimony that Mr. Knapp has the records,
He had some of the contracts because he was a sales guy.
but he wasn't the one that provided all the contracts for LGC, was he?
Right,
Most of them.
this is content. Let's keep it to the order and what has or hasn't been produced. This is not a discovery deposition.
Did you call up and ask Mr. Ortuno for accounts receivable and accounts payable?
I told
Did you call EZQ, Ezekiel Ortuno, the owner of EZQ, did you call him and ask him for accounts payable and accounts receivable?
the group of law firm.
Did you ask him for the accounting records using those terms?
I don't use those terms. I just say you need the records of the county.
And so, did you produce any accounts payable or accounts receivable?
Yes.
I wouldn't mind the Uber Eats part too. Not just Louis. I'm not just that mean.
If there's only what's the difference with an aging report versus accounts payable and accounts receivable?
I don't know. What account?
What was the title of those accounts payable and accounts receivable? What was the title of the document?
Rules and laws.
Pardon?
Rules and laws, I think.
And did you
Profits and loss.
provide them to your counsel? This big voluminous group of accounts receivables, monthly accounts receivable and accounts payable for years 2021, 2022, 2023, and 2024.
You know, I'm not sure, but he said whatever we asked, he said it. I mean, he's more open to talk, he's more open to talk.
How many pages of accounting records do you contend you produced?
I don't produce the documents.
More than 200?
I've been lying to you, it's a totally wrong, I don't know.
Do you, was LGC during the years 2021 to 2024, did they have any other bank account besides the Capital One bank account?
It was the one that Granger where this gentleman worked.
I'm sorry,
We had another account with Granger Bank,
Ranger Bank?
Granger.
But there was nothing in,
Giancarlo's work for it.
there was nothing in there, was there?
He opened the account for us.
So, other than allegedly Granger and Capital One, was there another bank account where you deposited money?
We opened one in 24, but that was after. Now we was on the Chase line.
Do you yourself own a bank account ending in 9555?
Yeah,
Does your wife have a bank account ending in 2416?
I'm not sure of that.
And it's your contention that that is not an LGC bank account? The 9555?
I'm not sure is my personal or is LGC account.
That's what I'm asking. I'm asking you. Do you know if that's your personal or if that's LGC's?
It's hard to remember what account number.
I think it's the 295th in Houston, in Harris County, Texas. I think. I don't remember.
Were you ever asked to collect the investment or loan contracts in this matter?
What exactly the question I don't understand? Collect how?
Investors in LGC during the years 2021 through 2024?
Investors.
Under the mattresses for other things, Michael, not money.
No investors? Did anyone make loans?
No,
I'm sorry, I didn't mean to cut you
it
off.
was a loan.
It was a loan, and who made this loan?
One is Alfonso Perez, And the other one is Onyx, which this gentleman worked for Onyx as well.
And who is Brian Coljo?
Brian call you too? On money?
And there was a contract with Brian, correct?
Yes.
Did you produce that contract?
I don't know.
What other investors or lenders were there to LGC?
Believe they want one more.
Did you produce that contract? Did you ever compile any document that identified the contributor by name, address, and phone number?
It's not really difficult question for me to understand. Can you be more specific?
Did you ever sit down and make a list of who the investors or lenders were for LGC?
I just told you the three names that I remember that I know.
And we know that at least two of those contracts were not produced, correct?
I believe we give it to the
I am seriously struggling, guys. Live stream's going on, chat's going on, everything's fine, and then all of a sudden Michael and Bobby both scream at the same time, porcelain. Why? What did I miss? I can't figure it out. I can't put it together with something we were talking about. It's just out of nowhere, two separate people say porcelain at the same time. What did I miss? What did I miss?
journey before.
Did you switch your emails for any correspondence with the investors that you mentioned?
I didn't know I had to send emails.
You didn't know you were to include emails with the contributor relating to contributions or changes in ownership structure? Did the membership structure, any of the investors that we just talked about, did they ever get a membership interest in LGC? At the outset, there were two members, correct? Michael Knapp and your wife? So it's your testimony.
The only member, the only owner is being Vilma Salgado all the time.
Has Ms. Salgado ever represented to the IRS that somebody else was a member?
The question again?
Objection, Your Honor, hearsay.
Your Honor, if they submitted LGC's tax return showing the membership interest, I think that's directly relevant. So I just wanted this witness's testimony.
Okay, it's overruled. Just so that I'm sure, Mr. Ramirez, you represent both him and her, correct?
Yes, Your Honor.
Okay, great, thank you. You can re-ask your question.
Pardon?
You can re-ask your question. The objection was overruled.
Thank you.
Oh my gosh, I figured it out, guys. Okay. Let me show you what just happened. Let me get an image up on the screen. Because you just so you don't think I'm crazy. I'm not. I am. But I'm not. Alright, here's my chat. Here's what I saw. Alright. We're chatting about a mattress under the mattress bank. And then look, Michael and Bobby just both shout porcelain. And I couldn't figure out why. Right? But if you notice, it has a translator beside it. If I scroll my mouse over JK, just said porcelain to me in the chat. Just said porcelain. If I scroll my mouse over it, it says chinny. So you probably typed chinny and it translated it to porcelain. That's why you said porcelain. Figured it out. We got there, guys.
Have you ever seen an IRS tax return that claims somebody else is a member of LGC?
Yeah. I've seen that, 21 and 22, it was 0.01% for Mike Knapp.
Were there any membership ledgers that showed his percentage?
Yeah. It's in the tax return.
And was there an operating agreement of this entity?
No.
I don't think I have any further questions of this witness.
Okay, you have any questions for your,
Yes, Your Honor. First of all, I'd like to ask, what did you say to the process server?
When they,
Let-
already had instructions on the email. They just heard about the email, I don't know how it's active, but I can see emails when somebody sends it from here from the court.
I think we need to stop, okay? You are asking for criminal contempt and jail time, correct?
Or whatever sanctions the court deems appropriate.
Okay, but you are asking for confinement.
I asked for lesser sanctions too, Your Honor, such as striking pleadings, discovery.
In reviewing the order and the request for criminal contempt, I need to read him his rights. And I did not do that. Right? So we're gonna stop. She has asked for confinement. She's asking to keep you in jail because you failed to comply with this court. Based upon that, I have to read you your Miranda warnings, all right? You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have him present
Translation, it's not going well for him, guys.
by you are being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you for any questioning if you wish. You can decide at any time to exercise the right and not answer any questions or make any statements. Do you understand each of the rights that I have just explained?
Yes.
Okay. You want to take a moment to talk with your lawyer. You want to take a moment to talk with your lawyer.
Hi, Robert. Okay, what happened was he was supposed to give a whole bunch of financial documents. He didn't. Then he lied to a process server, but that wasn't allowed because that's hearsay. And then the lawyer will not stand up when he's addressing the judge. 20 months. Thank you, Robert. Thank you so much. Thank you. Now, he could possibly go to jail right now. So he went to speak with his attorney, which I'm positive I cut out. And now we're just sitting here in no sound. Because I tried to fix the sound so many times. Alright, I'm just going to bump it a little bit. Here's something.
But nonetheless, you didn't review what was produced. Okay, so you don't know what, if any, contracts were produced, do you?
I know the main ones, like Burnside, like Provier. There was the most biggest contracts that we had, Provier, Allpro, and Hilltop. I didn't review them.
We're almost
I didn't
to the
know
end,
that
guys.
Those
We
are
almost
the
made
biggest
it.
contracts that we have. I don't even know the amounts.
I'm sorry, what was the last part?
I didn't know what is the amounts on those contracts. I just know that we got work with those guys.
And Your Honor, I think he opened the door to the affidavit by asking his client about it.
Okay, I already ruled.
And you say, do you recall what you told the process server?
Excuse me?
Do you recall what you told the process server when he tried to serve Vilma 8 times?
He only went one time to my house when I was there, and the second time that he went, and the other one wasn't there either. And it's only 2 times, so I don't know where is the other 6 times.
I don't think I have any further questions because it's established that he received check us.
Okay, is there anything further?
Not this time, Your Honor.
Okay, thank you. Sir, you may step down. Call your next witness.
Your Honor, we did not receive any.
Call your next
I
witness.
have no further witnesses, Your
Okay,
Honor.
great. Thank you.
Mr. Knapp is in the hospital.
All right. Mr. Ramirez, do you have any witnesses you wish to call?
Not at this time, Your Honor.
Okay. Client's name is Carlos Rodriguez, correct?
Yes, Your Honor.
Okay. At this time, the court finds that Mr. Rodriguez is in contempt of court of the court's order. However, I'm going to I'm going to sentence him, okay, to 3 months in the county jail for failing to
90
comply with
90 days in jail. Don't worry, he doesn't go to jail. 90 days, though.
the court's order. But at this time, the court will suspend that sentence if on or before March 16th at 3:15 he has complied with the court's order. Mr. Rodriguez, come up here next to your lawyer. This court is finding you in contempt of her order. You have violated a court order. I ordered you to produce, for instance, okay? The account application, the signature cards, signatory approval or removal cards on all of the bank accounts held by LGC. You have not done that. Okay, I ordered you to produce I ordered you to provide an affidavit. You have not done that. Okay?
I don't know why. It doesn't matter. It doesn't matter. So he has, 10 days to provide all of these documents, or 14 days, I can't remember. Or he goes to jail for 3 months. She's going to send him to jail for 3 months. Do you think he's going to provide them? He said he never read the court orders. That's what nailed him. As soon as he told her he didn't even read the court orders, she was done with him. All right, let's move on to... No. This one doesn't have a verdict. But JK is here. So we'll know what the judge is going to say. Just listen to JK.
Judge Spataro and Mrs. Elkhart, Superior Court number 5. We're going to get started with our 2 o'clock hearings. For folks, it looks like a good portion, if not all of the cases, all but one of the cases for this shift are related to an eviction. And I am required by order from the Indiana Supreme Court to make an announcement before every eviction hearing about something called the Pre-Eviction Diversion Program. That is a program that was put in place during early COVID times. It is a program that could lead to the possibility of back rent, sometimes even front rent, being paid for certain qualified individuals by the government. That's the good news. More good news is if both a landlord and a tenant are in agreement that this court should stay the proceedings or call a big timeout to allow time for an application, then I will stay the proceedings. However, the bad news is twofold. Number one, I understand that the program is temporarily out of funding. And number two, even when there is funding, I understand it sometimes takes 3 or 4 months for the government to process those applications. So unless I have unanimous consent of landlord and tenant, because many landlords cannot wait 3 or 4 months for the decision to be made, we will talk about the eviction today. All right, that being stated, looks like Mr. Greiner, you have one case for RDK Property Group LLC.
Yes, Your Honor. Good afternoon.
Good afternoon, and I believe Rachel Lambden and Edwin Winfred are here. You may come forward, folks, and have a seat at the defense table. This is case
Sally. Hey, Sally. It's been a while.
2602 EV 207. I also, I believe, have a representative of RDK. Ma'am, what is your name for the record?
My name is Terry Lewis, or I go by Terry. It's Teresa.
Okay. And is Teresa TH or just TE? TERESA. And then last name again?
LEWIS.
Thank you very much. All right. Folks, did you hear the pre-eviction diversion announcement I just gave 2 minutes ago? Okay. Mr. Greiner, is there any interest in that program here?
No, thank you, Your Honor.
Okay. What is the status of things from the plaintiff's perspective?
Judge, from the plaintiff's perspective, my client relatively recently purchased the real estate and has not been able to establish any landlord-tenant relationship with the defendants. There is no lease.
JK, I hope you're paying attention because I really want to know what a judge is supposed to do in this situation.
Rent has not been paid, and so that's what brings us here today.
Okay. And from whom did RDK Property Group LLC purchase the real estate?
That's a good question. Let me, I can give you the answer. It'll take me just a minute.
Leighton Taylor.
Say again?
Leighton Taylor.
That sounds correct to me.
Leighton Taylor, is that an individual person?
Yes,
Male or female?
it's a male.
Okay, so Mr. Taylor. All right. And folks, did you have a lease with Mr. Taylor?
We did. We had more than just a lease. I have that, and I have supporting documents that he wrote, text messages.
I can have my assistant come get those.
Personal things that he wrote before he left.
And I'm happy to take in all the documents,
Okay.
but in a
I didn't know what all you
nutshell,
needed.
is that you said you have more than a lease?
Well, yeah, we had provisions on our lease because actually the property, when I went to take over the apartment,
Indiana.
I couldn't take it over because it was built like it had to be reconstructed. So I had to gut it, and he was supposed to buy materials, never happened. And it's all in the lease.
I'll take a
But,
look at that. What's the term? What was the end date of the lease?
And date, it's not, we signed a 3-year lease.
And when did you sign it?
2024, but he moved out. So there's another
Go
document
rest,
that he had us write up
Rest.
stating that he was leaving and that we were occupying the whole home. But there's been a number of issues with that. The thing is that he handed it over to him because he knew he couldn't bring me to court because I'm taking him to court. Because the lease, he's breached everything. I mean, there's a lot in it that
Let me take a look at what you've got. And
there's a number of things. And then I have documents he wrote out before he left.
give me 1 second to.
So to summarize real quick, this tenant signed a 3-year lease and paid in advance. The lease is completely paid up until May. So most of the time is already done, okay? Now, someone bought the house in between that time and they're not paying rent to this new person because they've already paid up until May. So what is the judge going to do now?
Okay.
Do some review.
And I have pictures.
I'm just going to tell you what I think, and I don't know. They already paid. It's a contract. They're fine. The new owner has to go after the old owner for money. That's just what I'm guessing. I don't know. I have no idea.
I have text messages.
I'm gonna have this be scanned into the case. Mr. Greiner, what's the plaintiff's response to defendants advising the court that they have a 3-year lease that runs until 2027?
Judge, I haven't seen the document, and it is not consistent with the information that my client had. That's really all I can say at this point.
Okay. So folks, typically I don't usually conduct trials at these hearings. Quite frankly, 90+% of the time, people either agree, yes, I'm behind on rent and I'm gonna get out, or they say, no, I'm current, and they make some arrangement. But
He didn't,
I think
JK, he
the
didn't.
facts of this case are unique enough that, I mean, I can dive into the issues a little bit just to try to see if I can get some clarity and promote resolution. But ultimately, because I've got over a dozen people behind you and we set 12 of these for an hour designed to take 5 minutes each, I'm not inclined to do a full-blown trial on the spot. But I will ask, for Ms. Lewis, could you please raise your right hand for me?
Yes.
Do you swear or affirm under pains and penalties of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God?
I do.
You may put your hand up. What is your full name again?
Teresa Lynn Lewis.
And Miss Lewis, are you an employee or an owner of RDK Property Group?
Employee.
Okay. What is your job title?
An assistant.
Okay. And do you have any information about the sale of the property in question from Leighton Taylor to RDK?
Some,
What do you know about that transaction?
just that it had transpired a little over a month ago.
Okay, so sometime early February this year?
I'm sorry.
It's January 14th, I think, was the.
Okay, so, and was it your understanding that RDK paid a sum of money to Leighton Taylor to get title to this real estate?
Yes.
And did Mr. Taylor advise RDK that
Don't listen to T. We're all judging you. All of us.
there was an existing 3-year lease?
Not that I'm aware of.
Okay. All right. Well, that's the key. Not that you're aware of. I don't know who else might be aware of. I think what I need to do, folks, is set the issue of immediate possession for an evidentiary hearing. And typically, my magistrate, Dean Burton, will preside over those. So they'll take place in this courthouse, but not in this courtroom. It'll be 2 courtrooms over. I am.
Dean Burton doesn't stream, so we can't get the answer. That's why we had to figure it out ourselves.
4C, he is 4A. And what I will do, because I know that immediate possession is a time-sensitive thing, typically he schedules his trials a month or 2 down the line, a little more than a month down the line. But I can ask him to expedite this and get something on the calendar in 2 or 3 weeks or so to get some resolution for everybody involved. I will say, Mr. Greiner, the lease will be scanned of record, but I'm not sure, did we already give the lease back? It won't scan here. When it comes back, I'll ask my bailiff to give you a copy so that you can look at it, and then you'll at least be aware of it and you can see it from your office online.
Judge, if I could also just ask Ms. Lambden, I haven't seen the lease. I don't know what the terms are regarding rent, but my client certainly says that no rent's been received. I mean, Ms. Lambden.
The rent is paid up
Paid up through when?
to May, and I have text message documents. And the thing is, he made an agreement with us that if we paid him up early, the damages in the home, which I don't know if you've been in the home.
No.
Well, I have pictures of the whole ceiling. You can see through my dining room to my attic. Like, we were supposed to take care of that, and he's not a very truthful person. But I have
All that
pictures to
doesn't
show,
matter.
I mean, if need be. But there's a lot of damages here. This is my dining room, and I paid him ahead. He did 5 months throughout the summer, so we could fix this, and he just, yeah.
Okay.
Like I said, I have a copy of the text messages.
Well, I mean,
And
How much you want to bet the new owner had no idea there was big, huge hole in the house?
that was the reason that see, he initially tried to tell me, you have to get out. Like, today. So he brought the cops, and the cops told him that he would have to take me to court. But the thing is, I'm going to pursue to take him to court because we've had health issues because of this home. And the lease, there's a number of things that he just didn't keep up on. And he knew that it was going to be an issue if he brought me. That's why he passed it on to you.
So folks, nothing about my referral to my magistrate prohibits you from carrying on conversations. I have no idea how open RDK is to allowing the defendants to stay there if they pay rent. I'm not certain how willing the defendants are to pay rent to continue to live there, or if they want to vacate because it's not a healthy place. But certainly those are things you folks can talk about. I am simply going to make a referral to Magistrate Dean Burton, and he'll get you on his calendar and issue notice. Now, folks, I will tell you, Mr. Greiner is an attorney in the area, so he knows we send out electronic notice of trial dates or evidentiary hearing dates, etc. Folks, and therefore I have his email address. Folks, I only have, I believe, a tangible address, the address of the property. Would you like to provide an email address so you get a quicker notice?
Yes, please.
Okay, and then my court reporter will take it down if you read it slowly and clearly.
Okay.
Okay, thank you. So folks, very importantly, usually from the time that I make a referral, Magistrate Burton will get that on the trial calendar the same week, later in the week, give or take. If you don't see anything in the next 7 days for sure, by next Monday, I would recommend checking the docket. You can go online and look at my case and see. Mr. Greiner, you probably know how to do that for defendants. There's that tan piece of paper in the corner. You know how to do it. So you can look up your cause number and see what the trial date is. I can't tell you how many times I have people who miss their trial or their evidentiary hearing, and then they say, I never got notice. So I have made it my practice to make it very clear when I make a referral, it's on you. Okay, if you don't see anything, please don't sit back and assume, oh, I know the judge said he sets it the same week, but he's gonna take his time on. I'll just sit back and wait for a month. That makes my court very inefficient, and I don't want it to be inefficient. So please do your part, and if you don't see it in your email, check your spam folder. If you don't see it in your spam folder, either go online, my case, or call the clerk. But just know that we are gonna recommend to Magistrate Burton, given that it's the immediate possession issue that's going to be tried, that it be set approximately 3 weeks out, if at all possible. And Magistrate Burton will have his own order that'll go out with whatever he deems appropriate for exhibits and things like that. Any questions from the plaintiff's side?
No, thank you, Your Honor.
Any questions from defendants? Did you receive your documents back yet?
Yes.
Okay, and Mr. Greiner, did you get a chance to view them?
I did not.
Okay. If you wouldn't mind, I think it would be appropriate.
So just so you know, a few of you are just wrong. Just wrong.
Since they were submitted, typically I ask my bailiff to show them to the other side before they come up. If you could share just the 4 pages of the lease, would be helpful. And then just know that they should be in the docket of this case by the end of the day. Okay.
So if they were smart, somebody would subpoena the old owner for this court case coming up.
While we're here and all together, give me a moment. I'd like to pull that up again because I looked at the language, but I did not look at the signatures. And I will get my eyes on that.
All right, we're good. There's only 20 more seconds. I don't think he's going to say anything spectacular. All right, guys, we made it to the end. Thank you so much for coming out today. Appreciate it. Thank you for coming out last night. Appreciate it. I shall see you in 22 more hours with some court cases. I think tomorrow I'm going to play court cases instead. Maybe. We'll see. Maybe the sounds will even be together with the hand gestures tomorrow. Who knows? Let's not get crazy though. Thank you so much for coming out, guys. Have a great day. Bye.
Well, I thought thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in